So glad you could join us, everyone. The Court of Appeal in Abuja has declared as unlawful the abduction of separatist leader Nnamdi Kanu from Kenya. The court consequently quashed all the charges filed against him by the federal government. The court also ruled that the Federal High Court did not have the jurisdiction to try Kanu. In a unanimous judgment, a three-man panel of the appellate court held that the federal government breached all local and international laws in the forceful rendition of Kanu to Nigeria. Kanu leads the proscribed Indigenous People of Biafra group, which is campaigning for the creation of an independent state in southeastern Nigeria.
Well, joining us now are Arise News analyst Frank Tietie and our judiciary editor and deputy director of news, Soniyi. Thank you both for joining us on the news tonight. This is definitely a developing story, happened a couple of hours ago. But let me begin with you, Frank Tietie. You're also a lawyer. What's your assessment of this judgment? I've been reading different interpretations to it. Is the dismissal an acquittal? Is Kanu a free man?
Oh, well, yes, indeed. And the first reaction is that this is highly unprecedented. Nobody saw it coming, even though many lawyers agreed with the lead counsel to Nnamdi Kanu, Michael Zekoma SAN, that his arguments are quite valid. You can't build something on nothing. You can't be a beneficiary from the your own criminality, your own attempt to disrupt the international legal order. So these are very valid arguments, but considering the history of recent decisions from Nigerian courts, both at appellate and courts of first instance, nobody saw this kind of judgment coming. So today it's a very happy day for anybody who is law-abiding, realizing that, again, the judiciary has come to the rescue of those who actually thought that there was no hope. And this is a very good development, considering that issues that would have brought a lot of conflict, that would have led to loss of life and flexing of muscles and extreme violence, can easily be resolved on the platter of justice, just as the Court of Appeal has done. But it may not yet be uhuru for Nnamdi Kanu. Yes, indeed, he has been discharged and acquitted by the Court of Appeal, because the position of the Court of Appeal here is that Nnamdi Kanu is the federal government cannot even attempt to try Nnamdi Kanu when it has proceeded on a very grievous wrong in the first place. And the Federal High Court ran away, shied away, and did everything possible to avoid the very strong question as to where was Nnamdi Kanu arrested, at what time and at what place, and under what process. And the federal government kept on avoiding that question. And to see that a panel of Court of Appeal justices could be this courageous, a reminiscence of the dark days of the military, even where you had courageous judges at Court of Appeal and Supreme Court. But even in our democracy, we didn't have this, we didn't expect this. To think that enforced disappearances, as we have it in Nigeria, always having it, law enforcement in Nigeria has always practiced enforced disappearance of citizens, and it has become a norm, and they thought they could also extend it to the international community by going to another African country to show the might of Nigeria by abducting, seizing a citizen, not necessarily a citizen of Nigeria alone, but a dual citizen, bringing him to Nigeria. You expect the Nigerian courts to adopt that. So what the court has done today is impressive. A reminiscence again further of what happened to Umaru Dikko. And to think that it was the same now President Muhammadu Buhari that was military head of state at that time, shows that there's something really wrong with our psyche in the way we operate the law.
All right, let's bring in Soniyi. Now, among some of the other things the appeal court said, with appalling disregard to local and international laws, the federal government has lost the right to put the appellant trial for any offense. Now, with this ruling by the appeal court, Toby, do you think it creates a path to a political solution?
Yeah, obviously, it's an opportunity for both the government and the separatist group to reach a compromise. For me, it's the judiciary is providing the government with a face-saving opportunity to resolve this crisis. If they are interested, because what the Court of Appeal has done is to explain the law, put everything bare, And for me, everybody in government should read that judgment. The Attorney General of Federation should read that judgment and should advise government not to bother to appeal against it, but to see how they can use the opportunity to talk to the group, to talk to like other relevant body like the Ohanaeze Ndigbo and other groups, so that Nigerians can at least, experience peace, both in the Southeast and elsewhere. So let us remember that the Nnamdi Kanu case is, to a larger extent, a political issue. For me, it's not a legal issue. I also admit that people have died, people have lost their life, police, security agents as a result of this. But if we go back to the basic, this issue is political. And I'm not sure, I've even asked people, if Nnamdi Kanu is convicted, it's not likely to resolve the crisis. All this while, the impression we were given is that if he's arrested, the killing in the Southeast will stop. Since Kanu had been in the detention, has the killing stopped? The answer is no. So it does show that it's a political issue, and government should be able to seize the momentum and engage with the people that matter and see how we can make progress and restore peace, especially now that we are planning to hold election.
Indeed. Frank Tietie, I saw you nodding while Mr. Toby was speaking there. This was a unanimous judgment, a unanimous decision rather, and you praised the Court of Appeal as being courageous. Toby there said it creates a pathway for a political dialogue. But what do you think? Do you think that the federal government may be pursuing this further to the Supreme Court?
Well, the Supreme Court may not give a different decision from what the Court of Appeal has done. Let us understand something. It is not a criminal matter. It's not criminal for anybody to campaign for secession or for self-determination. But the processes adopted in such a campaign may be criminal, and such forms of crime could actually be tried in court. But you see, what this Court of Appeal has done today was to send a very strong signal to the Nigerian government that you cannot continue to operate with illegalities against your citizens, as it happens oftentimes in this country. The courts have not been forthcoming enough in condemning or deprecating the attitude of law enforcement agents, particularly the Department of State Services or the police in general. But to now think that they've moved on to a point where they've gone to another country to now abduct a citizen and then bring the citizen back, and then to now use the court as a cover to now put that person in a gulag is something the courts, would have, really did not agree to. So for me, it's not about a political decision. I don't even see it as a political problem. The charges against Kanu are very grave. However, you cannot, as a country, proceed on such level of, illegality. Now, what I now expect is that the president should read very clearly that he has not only been misadvised, but the law enforcement agents and particularly the Attorney General of the Federation did not do well in approving such an action. And when it was taken, some form of correction should have been applied. So that political solution you are talking about should have been the first course of action, not necessarily taking Kanu to court. Right. Now, this is important because we're talking about terrorism. However, Nigerians are some of the most terrorized people on earth, and they are not only being terrorized by Nnamdi Kanu and his group, but we know the other groups who have considered themselves as huge terrorists to the Nigerian populace. Have they been given have they had this kind of concerted effort on the part of government to ensure that they chase them out of town, chase them into whatever country, whether it is Sudan or in Liberia or anywhere, and then bring them for trial? Why is it Nnamdi Kanu? So I think The Court of Appeal in itself is giving the political solution by speaking the truth and justice to the matter.
All right, Toby Soniyi, well, Justice Adebola held, among other things, that failure of Nigeria to follow due process by way of extradition process as prescribed by law was fatal to the charges against Nnamdi Kanu. Help us understand what the process really should have been. What really is this process in trying to extradite an alleged criminal or someone who's taken up arms against the state?
Yeah, thank you, Ngozi. There are procedures. First, let me start by saying that countries enter into agreement between themselves and among themselves that we have such agreement with the Great Britain where Kanu was living. So they don't need to lure him to Kenya. They need to formally write to the British government through what we call mutual legal assistance. It exists between the two countries. Whether the UK will grant it or not is another thing. But at least what the treaty says is that the federal government should apply to the British authority that this person is a fugitive, he was undergoing trial and ran away, and therefore we demand that you send him back. And then the British authority will review the applications and decide whether to consent or not. But we cannot, as the Court of Appeal said, take the law into our hand. Nigerian government became lawless, took the law into his hand by going to Kenya. They lured him to Kenya and then just took him. And the Kenya authorities disgracefully were denying not to know anything about it. And I think after this case, the Kanu lawyer will probably still have to go in civil cases to ask for damages because his right has been unduly violated.
Thank you. Thank you so much, Toby. We need to quickly move on from that. It's a developing story. Keep an eye on it. President Muhammad Buhari had said, when asked about this issue, he wants the judiciary to take its course, let the case take its course. The CJN was sworn in yesterday as a substantive one. I'm talking about Justice Ariwola Olukayode. Frank Tietie, he did make a comment yesterday that politicians should allow the judiciary function optimally as we count down to the 2023 elections. What do you make of that statement? Because some will say it takes two to tango.
You know, there is an increasing number of situations where the courts now have to play the role of electing governors and other political office holders for the people. That ought not to be. The courts are actually overstretched. The tribunals that are set up will deprive the regular courts of manpower to even deal with the large dockets of cases that constitute a very embarrassing backlog. So the politicians have actually constituted a big problem in the way they conduct themselves, especially during elections. INEC is not also excused here. So what the CJN was alluding to was that, see, please leave us to deal with matters that of justice and not concentrate on political matters as if we are created to be a secondary electoral management body that will not decide who has won, to the extent that someone who comes fourth will now be declared as a winner of a governorship election. And then the general populace will now be thinking that the Supreme Court is operating on a law that is made in mass or somewhere in space and not Nigerian law. So giving a very bad reputation to the judiciary. So I think that's really been a very worrisome issue, and the CJN has touched on it because it means that he is in touch with what's going on with the heartbeat of the people concerning what the judiciary is today in Nigeria.
All right, Toby, would you say that whatever political interference has been in the judiciary over the years, is it a self-inflicted pain by the judiciary itself? And some are saying maybe it is time to begin to look at reforming Nigeria's judiciary. Do you agree? What do you say?
Yeah, I want to agree with you, Ngozi. First and foremost, the statement by the CJN is, I want to say, is a statement at large. In the first instance, it takes two to tango, like Adesu has said. The judiciary cannot be absorbed of blame in this matter. To a larger extent, they dug themselves into the hole. They have been encouraging the politicians to be patronizing them. I mean, sometimes there are issues that should have just been sent back to them and say, go back to the electorate, let them vote, let them determine who wins this election. But you know, the judge had been, I mean, the court had continued to interfere in the electoral process. And like, I want to assume that the way my learned colleague, Tietie, explained it, is part of the thing. But the CGN may also be calling on politicians to stop interfering in the judicial process, I mean, by not reaching out to judicial officers. So that's why I said the statement is at large. How does it mean? I mean, is it saying that they should stop bringing cases before, I mean, electoral or political cases before them? Or is it saying that they should stop patronizing judges? The statement deserves some clarification. But at both levels, I agree with you, Ngozi, that look, the judiciary too cannot claim feign ignorance. They cannot claim not to be part of the problem. They've allowed themselves to be used by politicians, and the CGN should also talk to judicial officers too. Maybe to leave politicians alone. I mean, to stop patronizing politicians.
Okay, the Tietie doesn't agree with you. I see you nodding.
No, not at all. I think my learned friend has not been quite fair in that response. There hasn't been a time the judiciary goes for any case. It is the malfeasance of the political class and the inability of INEC to conduct free and fair elections that would make opposition party members congratulate themselves, congratulate the winner. That's why they approach the courts. They are the ones who always approach the courts. My learned friend Toby has tried as much as possible to be euphemistic about the issue of bribe. What is being the issue that is being widely held in the public space is that judges, particularly the ones at the superior courts of record, collect bribes. But it may not necessarily be so. Bribery is a big problem in the judiciary. It has not been faced head-on. But EFCC has tried it. This same Attorney General attempted to approve a sting operation against some Supreme Court justices. It didn't work. But you see, the protection given to the judiciary is such that it's difficult to actually establish bribery. So I will agree with Toby that yes, perhaps the ambivalent expression of the Chief Justice of Nigeria is that please don't approach judges, whether the lower courts or the higher courts, with bribes to give decision on political cases. But you see, when there are certain ways the Supreme Court or the Court of Appeal or the Federal High Court will decide a case, and you will know that justice has been served. And it will not cross the mind of the ordinary citizen or any lawyer that a bribe has been given. The issue of bribery and the restoration of the integrity of the judiciary is really important, and the main culprits are actually political office holders, and that is the political class.
Well, a lot lies on the table of Justice Kayode Ariwola, the CJN, substantive CJN, reforming the judiciary and, of course, bringing back confidence in Nigeria's judiciary. Toby Soniyi and Frank Tietie, both lawyers. Thank you very much for joining us on Newsnight tonight.